Hi everyone. Welcome back to Financial Path, where we break down complex financial issues and help you make smarter decisions for your money. On Wednesday, May 28, 2025, the U.S. Court of International Trade struck down most of Trump's tariffs on other countries. The court also blocked the levies the Trump administration imposed on Mexican, Canadian, and Chinese imports with the stated aim of combating the illegal flow of fentanyl and drug trafficking from these countries. However, the tariffs imposed on some specific goods like cars, steel, and aluminum remain in place because they fall under a different law, Section 232 of the 1962 Trade Expansion Act. The ruling ordered the Trump administration to carry out the necessary administrative moves to remove the tariffs in 10 days and indicated the relevant tariffs would be vacated, permanently enjoining the government from enforcing them. This means that Trump's tariff policy may collapse and Trump will have no opportunity to achieve his strategic objectives in his second term. However, whether things will truly go in that worse direction, please continue to watch. The ruling was based on two separate cases. The Nonpartisan Liberty Justice Center brought one case for several small businesses that import goods from countries targeted by the duties. A coalition of U.S. state governments brought the second case. The two cases went to the Court of International Trade, a part of the federal court system with specific authority over trade. After hearing, the U.S. Court of International Trade ruled that Trump's use of a sweeping presidential power, the International Emergency Economic Powers Act, IEPA, to justify his April 2nd tariffs and levies imposed on imports from Mexico, Canada, and China was wrong. First, the court noted that the U.S. Constitution gives Congress exclusive authority to regulate commerce with other countries and rejected the Trump administration's arguments, claiming the president had broad authority to impose tariffs under IEPA. Second, even though the 1977 IEPA Act allows the president to regulate commerce during a national emergency without the need to go through Congress, the three-judge court panel ruled that the economic concerns cited by the White House to justify the tariff plans do not meet the required test of being unusual and extraordinary threats. So the court ruled that Trump's sweeping tariffs under emergency powers law were illegal. The ruling's judges are Timothy Ray, 66, appointed by President Trump in 2018, Jane Restani, 77, appointed by President Reagan in 1983, and Gary Katzman, 72, appointed by President Obama in 2016. Minutes after the ruling was announced, the Trump administration filed a notice of appeal and questioned the court's authority. In a statement on Wednesday, White House spokesperson Kush Desai said U.S. trade deficits with other countries constituted a national emergency that has decimated American communities, left U.S. workers behind, and weakened the U.S. defense industrial base. Desai also indicated that it is not for unelected judges to decide how to address a national emergency properly. Stephen Miller, the White House Deputy Chief of Staff for Policy, also attacked the ruling in a post on X, claiming the judicial coup is out of control. On Thursday, the Trump administration filed for emergency relief from the ruling to avoid the irreparable national security and economic harms at stake. In general, the Trump administration is racing to halt a major blow to the president's sweeping tariffs after the U.S. Court of International Trade ruled they exceed any authority granted to the president. In response to the Trump administration's appeal on Thursday, the Federal Circuit Court of Appeals ruling allowed the tariffs to stay in place until the courts decide on their legality, temporarily invalidating the verdict of CIT. IEPA was crafted primarily to restrict transactions with foreign entities during declared national emergencies, not as a general-purpose tool for tariff setting. The court emphasized that IEPA doesn't explicitly authorize tariffs, and using it that way could be seen as an unconstitutional bypass of Congress's exclusive power to regulate foreign commerce. The CIT issued a unanimous decision and permanently enjoined the government from enforcing the tariffs. That's a strong signal that the judiciary is now more willing to challenge broad interpretations of executive authority, especially after years of deference under Section 232 and 301 cases during Trump's first term. A key vulnerability in Trump's case is the vague and arguably manufactured nature of the emergency used to invoke IEPA. Courts are generally more deferential when concrete national security risks, e.g., military threats or cyber attacks, are at stake, but less so when economic grievances or trade imbalances are framed as emergencies without immediate risk. Since earlier rulings that upheld Trump's use of Section 232, legal and public sentiment has grown increasingly critical of tariff overuse and executive unilateralism. Even some conservative judges now show more skepticism about expanding emergency powers for economic policy goals. While the Trump administration has filed a strong appeal and secured a temporary stay, the odds favor the CIT's decision being largely upheld. The appellate judges may narrow or clarify parts of the ruling, but they will unlikely fully reinstate the tariffs imposed under IEPA unless Congress explicitly authorizes such actions. So 65% likelihood the court's ruling is upheld, 35% that the Trump administration wins a meaningful reversal. Even if the latest court issues aren't resolved quickly or the Trump administration loses the final case, trade experts said Trump would likely have been able to impose the tariffs anyway, using other powers. Peter Navarro, one of Trump's top advisors, also confirmed that even if losing the case, the Trump administration will do it another way to keep the Trump tariff agenda alive, healthy, and will be implemented. These tools include Section 232 enables tariffs based on national security threats from imports. Based on this regulation, Trump already has tariffs on steel, aluminum, and auto imports. However, the statute requires the cooperation of the Department of Commerce and the Department of Defense to investigate and confirm that imports threaten to impair U.S. national security before invoking Section 232. The investigation can take up to 270 days, delaying the timeline for imposing tariffs. In addition, Section 232 can only allow tariffs to be applied to sectors where imports threaten national security rather than a broad range like IEPA. Once the report is passed, the president has wide discretion but can only target individual product sectors. Section 301 allows the U.S. president to apply country-based tariffs at a rate of his choice if the U.S. trade representative determines that another country is engaging in unfair foreign trade practices, such as intellectual property violations or market access barriers. However, the law can't universally apply to all imports from foreign nations. A justification must be made and followed, and President Trump can't unilaterally decide to impose broad-based tariffs. Section 122 allows President Trump to impose up to 15% tariffs for 150 days to address large trade deficits with other countries. Applying tariffs under 122 wouldn't require an investigation, so Trump could quickly use it to assess a broad-based import duty. Congressional action would be needed to extend the tariffs after 150 days. Section 338 empowers the president to impose new or additional duties up to 50% on imports from countries that discriminate against U.S. commerce. The law defines discrimination as when a trading partner's rules, import duties, regulations, or other restrictions disadvantage the U.S. No formal investigation is required, but the authority has never been used. The Trump administration could seek congressional action if it loses the ruling made by the Court of International Trade regarding tariffs imposed under IEPA. Trump could seek legislation from Congress to authorize him to impose tariffs under IEPA specifically. However, there is potentially significant opposition to the tariffs within Congress, so gaining congressional support for such legislation could be challenging. In addition, legislative action can be a lengthy process, requiring debate, committee hearings, and votes in both the House and Senate. Investopedia stated that the judge's ruling was just a roadblock to Trump's trade agenda, but it won't stop it. The White House is also confident that a higher court will overturn the Court of International Trade's decision on Trump's tariffs. From the previous analysis, we can see that the Trump administration will try to use many ways to keep the current tariffs in place, no matter what setbacks occur, so that Trump can achieve his strategic objectives in his election campaign. That is, to restore American greatness by putting America first, resolving long-term trade deficits, boosting American manufacturing, and protecting U.S. jobs. These show that the existing and potential future tariff lawsuit cases can only increase the uncertainty of Trump's economic policy and the U.S. economy. However, they can't change the direction of the tariffs going forward, and Trump will perform his strategy solidly to make the U.S. economy grow steadily. Trump was a successful entrepreneur. He could manage an enterprise successfully and be certain to lead the U.S. to a new peak point. As individual investors, you just need to take the historic chance to make a good long-term investment with your diversified portfolio until the next U.S. economic recession. You shouldn't be disturbed by any turmoil or similar uncertainty along the way. Thanks so much for your watching. If you find this video interesting and helpful, subscribe to my channel for more videos. Your support allows us to continue. See you in the next video.